and hi everyone online. So a couple weeks ago, I came and we had a conversation about just a very quick little session about powers of attorney versus personal representatives on when selling and on listings and all the ways that we get to deal with those. And there's a lot of questions and the things that brought up. Thank you. Brought up a lot of really good questions, and we just need to do that. So kind of dug in a little bit more mm, on both areas. So powers of attorney and uh, personal representatives. So people that are deceased, or the title, the people that are deceased but are have how their home has to be sold. So I'm going to start with powers of attorney, okay? And essentially, I'm going to try to remember to see it from your perspective and not my perspective, because I think it's really important that you guys know what we're looking for as lawyers and how to structure the transaction so that you're getting the proper information. You're making sure that your agreements are signed correctly so that you don't have to do amendments. You don't have to go back. You don't have to get people that are already working for other people's behalfs to kind of, no one wants to kind of do that. You want to just make sure you get it right person. So um, obviously, you guys know that real estate doesn't stop because someone's elderly, unwell, or passed away. But we have to have the right people to sign. So with a power of attorney, um, essentially it lets someone act for someone else when they're alive. So it ends automatically when that person passes away. Power of attorney is only good when the person is while the person is living. It covers finances, property, can cover both. So when you have got a situation, and how many here have had a situation of power of attorney? So it's common enough. Um, you always want to make sure that you see the original power of attorney and that you are dealing with the person that is supposed to be listed or that is listed as the person that can act for person on title. Okay. So there's two types of powers of attorney. There's an enduring power of attorney, and then there's a non-enduring power of attorney. That's typically either at the top of the power of attorney or in the document somewhere, at which case suggest you send it to your lawyer and say, if you have any questions, like, can you take a peek at this? Does this person have the legal capacity or the legal ability to sell this property and transact with me on this property? So enduring means that it survives any incapacity. So for example, dementia and Alzheimer's, that is when an enduring power of attorney comes into play, because you absolutely need it to be, it survives the incapacity, the fact that you're no longer of sound mind. Okay. So enduring, very important if you've got someone who has dementia, which in a lot of cases I feel that's what the people are dealing with. So enduring power of attorney. And the other thing is that it is for the purposes of real property. Okay. So there's some powers of attorney, and I know you guys probably have dealt with this before, but you get to a listing and the people that the representative that you're talking to literally handing you like a box or like a paper that says, here, this is what I have. This is I can act. This is what it is. You're probably getting the will. You're probably getting the medical directive. And the power of attorney is shuffled in there somewhere because they literally have just everything and don't really know. They need guidance. So you're looking for power of attorney, and then you're looking for enduring, or if they're just like in hospital or something, then it can be enduring. But and then you're looking for whether you can actually sell property. There's a clause in there. We'll say, I authorize my attorney to deal with any property that I sell personally. Okay, so that's really important.
What was you're looking at? A will?
No, so power of attorney.
It's just separate document.
Yeah, so you've got, so when you are thinking about powers of attorney versus the will, power of attorney is living people, all the parties are still alive. Power of attorney is alive. I've always tried to find some sort of way to like have like a little rhyme or something that still hasn't come. To try and remember like dead versus alive, and then will is dead. So if you're dealing with a will, someone's dead. If you're dealing with power of attorney, someone's still living. It's literally, that's it. So that it's that person just cannot act on their behalf. Um, so essentially, my next kind of thing to go over is you're going to ask 4 questions when you're going into a power of attorney listing. Like someone else is contacting you, I'm power of attorney for my mother, I'm power of attorney for my sister. Is she still living? Then I see a copy of the power of attorney. Does it cover property, not just personal care? It's not a medical one, right? And has your lawyer reviewed it or someone reviewed it? Okay. So no one is looking to stop the listing. Oh, like, I can speak for all the real estate lawyers in the municipality, at least, that it's really just we want to confirm that everyone has the proper authorization to do what they need to do.
So those 4 questions
Yeah.
are they still living? See a copy of the POA?
Yep.
Has the lawyer reviewed it, and is it for real property?
Does it cover property and not just personal care? Yeah. So because there's a lot of, we have a power of attorney for medical, power of attorney for financial. Property falls under the financial power of attorney. But yeah. So living will, people are saying living will, they mean medical. Okay. Anything financial is your enduring or non-enduring attorney.
Doesn't have to have a specific address. Just property.
Just property. There's specific powers of attorney. Say I'm going away, like a lot of military clients have specific powers of attorney. So they're being sick, and their wives or husbands are dealing with the sale of the property while they're away. They'll come in, they'll get a specific power of attorney. I authorize my wife so and so to deal with the sale of this address at this time and do any that they need to do. That happens, but most people are just doing the general power of attorney. Yeah. So those are the questions that you really want to focus on when you're doing that listing with them. And then one thing that I find is very strange still here with the land registration office is that technically you're not supposed to give anyone your original power of attorney. Every lawyer will tell you you shouldn't give that away. It's yours. You need to keep it. You might need it for, maybe you can do certified copies. For us to sell property and use that in the deed as a power of attorney, we need to register that power of attorney at the land registration office. Land registration office will not accept a copy. I have to ask every single person attorney for the original power of attorney. Then they tell me, I was told not to give it to anyone. I know. You give it to me. I'm going to send it down to the land registration office. Courier back. So it's a very strange rule. I typically have that conversation with clients. I'll just say to the realtors, just let me talk to the clients. I'll explain it, because if you say, we need your original, just as they should, they really shouldn't be giving it away. So then that's what I do. We send it down. It gets registered. And then when the buyer's lawyer said my deed is signed via power of attorney, will then go find it in the land registration system, say, oh, okay, this person really does the legal ability to sell it. Because they're signing their name for someone else. Okay, where did you get that authorization to be registered in the power of attorney role?
That usually like 8 weeks.
Oh yeah, yeah, same week. So as soon as I see power of attorney on an agreement, I'll reach out to the realtor or the client and say, okay, this is power of attorney, I'm gonna need your original. Can you bring it to me? Can you courier it to me? I'm gonna send it down, I'll courier it. That's done. We want that done right away. Nothing.
But it shows up right away though.
It takes about 48 hours. Yeah, it's not anything crazy.
Is that something that could be done as soon as you list the property?
Absolutely. Well, yeah, absolutely. Yeah.
And then it's being proactive,
Yep.
and then it goes faster?
No need to wait.
Yeah.
Right.
Well, and then when the buyer's lawyer is doing their legal review and they see power of attorney, they could actually check and see if the authorization is there then, would just be one less thing the lawyer would have to check. You're on.
Right.
Yeah, absolutely.
What if they say, I can't find the power of attorney? The lawyer's office, they have.
Yeah, so that's a great question because it happens, right? So for example, I get a lot of, I have a power of attorney. This is the copy. No, I need the original. If there is no original, typically we're going to need a certified true copy from the lawyer that drafted it, that we can submit with a copy that says it did see the original. Or if someone lost it, it's fine, then we can register a certified copy. If there isn't, sometimes they'll accept. Oh, it's really just certified copy.
The lawyers need to keep those on file, clients though.
Well, the original?
On the original, yeah, well, yes.
Oh, they shouldn't. They shouldn't. Because it's something, well, I mean, the bigger firms than to be able to, they have the capability, the capacity to store documents for clients. Wills, they have the, they've got security that they're required of our society rules to store personal property like that. Like, for me, we give all the originals and say in my covering letter, these are your originals, do not lose them. This is the only copy you have. It just depends. Something pop up, maybe no.
So joined.
Oh, okay. So that's what I have for power of attorney. I was going to move to personal directive now, unless anyone has any other questions about powers of attorney. Right. So now the owner's passed away. So power of attorney's gone. It's no longer applicable. Authority transfers to the estate, managed by the personal representative. Okay. So you've got executor who is listed in a will, is a document that's drafted by a lawyer that provides for deceased's wishes. Then you have a personal representative. Personal representative is the person that is legally allowed to sell the property because it's gone through the probate process of giving the executor legal ability to sell the property as a personal representative.
The executor.
Yes. Only the personal representative is allowed to sign off on deed under a estate deed, not an executor. When we're dealing with property, anything else the executor can deal with, like bank accounts, things like that. But for when you're going through probate, maybe I can back up and go through probate as well. Probate is essentially you're legalizing and the will, making sure that the legal will, it goes from deceased's name into the executor's name, who is then known as the personal representative. They have that ability. They have the beneficial. They hold that beneficial ownership for the person that died.
Is that the only person that you need to probate a will? Some wills aren't probated.
That's right. So it's because there's thing would be already joint. So there's no reason to transfer it over to yes, lay out the just of the will. Okay, so it's when everything is joint. So typically when you've got, let's say you've got an elderly couple, they're thinking, oh, they think they're going to list their home, some joint tenancy names. They've got, if one passes, it automatically goes to the other. End of story. Nothing really changes. All we need is a death certificate. We then register on title, show that there's a reason why this person's still showing on title, but we removed them by a death certificate, by a certain form, and then you only have one person that holds title. On the death of that person, unless another person has been added to title, that they will only own that property solely. So the only way to get it out is to go through the probate process. If you have a will, it's much easier. If you don't, you still go through probate, but you go through a grant of administration, not a grant of probate.
Do you ever have people or recommend to people that a child, an adult child is added to a deed? If it's a single parent that's remaining, so that that gets transferred and they can easily sell it and that portion of the will or the estate is not, doesn't have to go through probate.
Yes, but I always ask them or advise them to seek an advice before they do that.
Right. Because
If the child already owns property, then you've got capital gains question, even if it's not their principal residence, there could be consideration. Then there's also the potential problem that if they are on as a joint tenant to avoid probate, then upon the sale of that property, money is theirs solely and not in
Right.
representative of the estate. So if you don't have explicit trust with the person you're putting that on and it's to avoid probate, you've all of a sudden have one child that's just inherited the entirety of a house that was supposed to be split into people. So that is a very tricky conversation. It's a conversation that I have at least once or twice a week with clients that call and say, I'm gonna add my child to title. We sit down and I say, okay, well, this is what that means. So, from a legal perspective, upon the sale, that money is that child's, no longer worse for the estate is.
Okay.
Yeah.
So what about putting it in, like, you're hearing a lot now about putting it in trust?
In a trust.
In a trust.
Yeah, so that is something that for the most of the, I want to say, middle class people that are selling their homes or that are, basically just looking, they have one home, they've got, just their asset. There's a lot of significant costs and hoops to jump through to create a trust, then just to that trust and have that property being held in a trust. So there's in trust, which is like holding the money in trust, and then there's a trust agreement you would draft. It's like holding the property will be held in a legal trust. So I'm not really sure. I'm not.
If you put your principal residence in a trust, though?
I don't do any trust work. I don't do any trust work, so I'm not even sure if, I'm sure. No, I get that. Yeah, I don't know.
But you can, the best way around this is take a reverse mortgage. Your clients, their home paid off, tell them take a reverse mortgage, invest that money, it's a loan, doesn't matter. It's a higher rate of interest by the time they die, the property will probably, just pay off the reverse mortgage. That's what they will talk.
The inheritance, you mean early.
And give the inheritance. So take a reverse mortgage, you don't have to make any payments on.
Yeah, I think it's more, a lot of people, it's to avoid it's the probate.
It's the,
It's probate. It's the fact that it's a lot of work, it's a lot of time, it's this.
we're taking you away from your.
It's fine. But that's a lot of the reason why people they're direct to title. And if they're only one child and that child doesn't own any other properties, then maybe that's a situation. That's the exact situation where you want to do that. Definitely does depend on a lot of different things. Yeah.
And the trust is only valid for a certain period. So then you have to do it all again, and there's a second expense.
Right. But it's very costly. So the personal representative, when you're dealing, if the probate hasn't been granted, we're dealing with the executor. So the first thing you guys should do when you're the listing, or even as a buyer, you're looking on title and you're seeing, is the person at their side or that I'm talking to, is that deceased person still on title? Or has it gone through? Does it say will grant probate? Because while you can list property while that's happening, there's some lawyers that will say no, tell you that they don't want you to list the property. Really, there's two parties that want the same thing. One party wants to buy, one party wants to sell. It's literally just paperwork that's going to, that takes the time it's going to take to document. As long as there's a clause in the agreement that says this agreement is subject to probate being granted and closing will happen 10 days prior to or after the grant of probate, it's typically what happens. Because there's, when you've got clients that are taking on something for a deceased family member, say it hasn't gone through probate yet. Well, heating, taxes, mortgage, all kinds of bills that are coming at you that you need to get that off on the market ASAP. They don't have time to wait. They don't have time to deal with it. It's not their house. They want to get rid of it. So the fastest that we can, that you work through that with them, typically it's we're looking on property online, you're going to look and see whether it's already done through probate, which is great because then it can close ASAP, and typically want to close ASAP because vacant, no one's there, can move. Otherwise, first conversation you should be having is to your lawyer to say, Suzanne, I need you to check on the status of this probate because they're telling me it's almost done, that we can close in 2 weeks. Can you confirm that this is actually the case? The last thing you want to do is set your buyer up, your seller really, for unrealistic expectations that this is all going to happen. People start booking things, the bank really is not really, that they're just going to go with the closing of the agreement. Then it becomes very much an issue for both parties because everyone's moving their life around. So you want to make sure that you're talking to the right person. Sometimes you've got two executors, sometimes you have one. Make sure that you're talking to that person. Ask to see the will. You can ensure that you're actually talking to the right person. If there's a lot of disputes out there,
And get their ID.
and get their ID. Yeah, there's a lot of people that
If there's two people as an executor, because sometimes there are.
Yeah.
The two executors, you can only get to be the, what did you call it? The power of.
the personal representative. No, if there's two executors, there's two personal representatives.
Do I have to get them both
Yeah.
signed?
Unless one is renouncing, saying you can have the full job.
Be on paperwork.
That would be at the paperwork at the probate court. But you've got both people.
Sometimes the will can say this one or.
Yeah, okay, so or is a different story. I'm talking co. So I appoint Janice and Suzanne be co-executors. There's alternates. So if Suzanne isn't available, has predeceased me or incapacitated, then I appoint Janice. So if that first person still alive in a full sound mind and body, they're doing it, then that's just one. If it's co-executors, then it's two.
So often see with brothers and sisters, or two sisters or whatever, where it goes, oh, I have to have both my kids,
Yeah.
or all three of my kids.
Exactly.
It's a nightmare. So
It is.
you deal with, for any way to circumvent a problem later, like can you ask three of them or two of them or whatever, decide upon one person? Because if they disagree on the sale price of the house,
Mhm.
conditions.
Yeah. So it's funny, that's kind of a timing thing. So if you could, if you called me and said, I'm about to list this property, I've got 3 people that I need to talk to. I would say, okay, let me see where the probate's at. Let me see where these people actually live. Let me dissect the relationship here. Let's see if we can get or two to renounce or just say we don't want to actually be on paper for the executorship. We'll still help our sibling, that we only need one person to sign. Just file a form, you'd be able to list with that one person. But there's like moving parts to that because you have to like renounce at the probate court. You are no longer going to be, you're basically renouncing your right to be the executor.
Well, that's the time to do it though, because
Absolutely.
these haven't started adding up for monthly.
Yeah.
Mortgage
I'm
or-
gonna scoot through, because I know there's some questions on there.
Yeah.
This one's so cool right now.
Who's patiently waiting up there?
Susan,
I just have a couple of things to pop up. You're good. Yep.
Right, Dennis. I'm alive but feeling unwell. My power of attorney can act as well, but when I'm gone and life is still, my wishes are inside my well.
The last one's my favorite.
Wait, while I'm alive but feeling unsteady, my power of
No.
oh, read it, what's it say?
When I'm alive but feeling ill, my power of attorney pays the bill. When I'm gone and life is still, my wishes are written in my inside.
That's good. That's good. I actually like that. That's really good.
Yeah,
Oh,
that's
we got
my
pictures.
favorite.
Yeah.
Get a screenshot,
Yeah.
Dennis.
I sent it to myself in an email.
I'm feeling unsteady. My power of attorney is strong and ready. Good.
And then Suzanne, can you explain the probate process and timeline? All powers go through probate.
No, not all properties go through probate because if they are jointly owned, then there is no reason for probate. It's only when it's basically the last person standing on probate, or in the circumstances of tenants in common, which is going to become an issue in the next 10 years.
Yeah.
Because what lawyers have been doing since the provincial deed transfer tax came into play was to assist people in minimizing the provincial deed transfer tax, was to concern ownership percentage, the people on title. The only way you can do that is by the property owners owning the property as tenants in common. So typically, husband and wife, even children and parents, brothers and sisters, like typically, I would say 90% of the transactions are joint tenants, which means that you have an undivided interest in the property. Each person owns 100%. When one person deceases, the other owns it fully. Avoids probate. Until the end, until the last person standing owns it by themselves, and it needs to get transferred over to as the instructions as per the will.
Can I some clarification on what I was just looking for an explanation on for everyone to understand is perhaps probate with or without a will? So take tenants in common. The only person who owns the property is deceased. The timeline for with or without a will for
Okay, that's a good
probate.
question. Yeah, that's a good question. It depends by county. They're just like the land registrations offices, they are dwindling. There's less and less offices. Well, the same thing is, I think there's 4 or 5 counties with probate. Grant of probate with a will, about 6 to 8 weeks, if you're lucky, to get through the entire process. So if you have, which is why I said to you guys that the first question you have is when you see a state of, but it still says fee simple on property online, and it doesn't say will grant of probate. First question you should be asking is calling your lawyer and say, can you look into this? How where they are at this, where's the status? Because no one really understands from a layperson perspective what that timeline actually is. Like, oh yeah, it's gonna happen, it's happening. Like we're talking, they're working on their own time. So 6 to 8 weeks is a good, that's a good timeline. I'd say probably closer to 12. Grant of administration which is without a will, we're talking really is going to depend on the Intestate Succession Act, because you're following law versus possibility of the person's wishes, because there is no will. So you could be looking anywhere from
Year.
well, yeah, like typically everyone's getting along to 6 months. Like, they're not getting along, then
Yeah, it's-
yeah, indefinite. So it really does make a difference. So grant of probate is going to be this way. Grant of administration is going to be significantly longer.
I just
So
think
yeah, just- I
that's, I think that's key for people when we're talking about listing a property, because that to me
Yeah,
is one of
okay.
the steps that you should be looking into. Because again, like you said, the clause for close within 10 business days of probate being received is good. However, if it's something along that lines where it could be 6 to 8 months or longer, that is
Yeah.
a consideration for listing the property. So I think that's
Yeah,
very important
absolutely.
for people to
No,
ask.
you're absolutely right that of administration grant. Well, yes, first thing, let's back it up a little bit. If you asking to see the will, there isn't one, that's a major red flag. Major red flag. Because who's going to agree? Who's going to sell the property? Who has the legal authority to sell the property?
Unless there's like one child.
Yeah, yeah, but then they still have to like appointed to sell that property. Whereas if they're already appointed in the will, which is what we would have done, then that's half the battle. So it's you're literally you've died with no instructions. So you have to go to legislation. Who has the ability? Like, let's say for example, that person's still married, like the spouse is split up, never get legally divorced. But then there's 2 kids, but they don't speak to that dad anymore. And all of a sudden you've got a house with a lady that passed. The spouse has just as much legal standing the kids do. Who's going to agree to run the money, like to make all these decisions? So grant of administrations are actually extremely, that's a major red flag. Yeah. So that's a good question, Susan. Thank you for bringing that up. Yeah, back to provincial deed transfer tax. What's going to happen is that you've got properties that are no longer owned by joint tenancy that are just going to flow through. You're going to have people that are owning property at 99% for Nova Scotia residents, but then they needed their parents or other that lives in BC to sign off. They only own 1%. When you go to list that property where the 98% owner has passed, there's this 2% you have to get rid of and go through probate for to be able to sell the property fully. It's coming up in the next 8 years, and it's not going to be fun. It's not going to be fun. So when you list the property, you're listing it as estate of deceased name, right? The executor's name on that personal representative. So estate of person, then person that has the power to sell on behalf.
Suzanne, have you run into any issues currently with the tenants in common? I know that we're finding it because of the deed transfer tax, but have you run into them in regular practice? It feels like a fairly unique situation, probably more common with vacant land than it would be for property with a home on it.
No, actually, I've had more people pay the provincial deed transfer tax on vacant land and try to get around it.
Really? Interesting.
Mm-hmm. Was really surprised me. The one thing that's gonna be the worst is because every time that I have a tenant in common situation, I say the only way you're going to be able to deal with this percentage is by putting it in your will. If not, then it follows the rest of your will. So 2%, if those people don't change their will, say I own property in Nova Scotia at 2% interest, I want that property to go back to then it goes directly there. There's an answer to that, where that 2% goes. If they leave that undocumented, falls in So you could have that 2% have 5 people signing off. Because those are the people that are titled to that 5%, that 2%. Yeah, I'm confusing you.
Based on the regular flow of the will.
Yeah.
So
like-
it's, okay, okay,
Mhm.
that,
Yeah.
that's horrifying, but it makes sense.
It's gonna be.
That's going to be really scary. So when people are getting into a situation like that, because we are running into that now with, I'll use an example of students coming here and they, they have the ability to purchase a property, but they still need a guarantor, someone to sign on with them in some capacity. So that could be happening. So as part of that conversation, if they don't already, then to produce a will that actually includes this as a very specific line item to say XYZ should happen with this percentage of this real property. Okay.
Absolutely.
Wow.
Absolutely.
Okay. Very good. That's interesting and terrifying.
Yep. So let's. Any questions?
Blind get a will.
Bottom line, get a will and have a power of attorney. Okay, let's talk about if there's no power of attorney. You can't sell the house. One person is incapacitated. The only way that anyone's selling the property is the guardianship. The guardianship application to the Supreme Court of Nova Scotia. It runs about between $15,000 to $25,000.
How long does it take to do that?
Oh, there's 6 months. Could do an emergency one, but then you're paying.
10 to 25. They set something to assess the person.
Yeah, absolutely. Yeah. So for example, I had one in end of August. I had a realtor call me and say, the client is starting with Parkinson's. Well, has Parkinson's. Can't really see. He's still living in his house, but with his live-in caregiver / girlfriend. So, and they want to sell the house. They want to move back to Cape Breton to have more support for his family to look after him. So that's why I say, does she have a power of attorney? No. Well, but they say, well, he does understand like what we're talking about, like. Okay. So then I said, well, before you do anything else, you have to have that guy assessed. You have to have that man assessed by his doctor. And I have to see a letter of the doctor that says that, okay, I can do a power of attorney. I will do a power of attorney document if the doctor says that man understands what's going on, and then I'll explain it again, and we'll look at each other, and I'll assess that legally. And he can sign an X. It doesn't have to be a signature, like as long as I can see him sign, and that's fine. So he gets assessed 1st of September. Doctor sends me a fax and says, this man has absolutely no idea what's happening. Absolutely. I had no idea. He shouldn't be doing anything. So they had to call a guardianship lawyer and to go through the court process. So it's like, which costs a lot. It's a lot. Yeah. And in the meantime, you can't pull any of that equity out of your house because he's the only person on title. And you can't, there's no mortgage on it, but you can't get a mortgage because they get incapacitated and there's no money anywhere. So it's like, it gets dire really, really quick. Yeah. So power of attorney, wills, super, super important. So when you've got clients that have them.
Will be one of the first conversations we have with everybody, no matter how old they are.
Yeah.
Do you have a will?
Well, it's a great real estate. It's great for that. It's a great segue into, okay, you've just purchased your first home. Let's get you set up. And I'll tell you why. This is what would happen.
Yeah, but 3 years later, you call them and they still haven't done it. Right, whatever.
But you feel better.
Yeah, you told them. I'll write it.
Oh, absolutely.
And they copy their lawyer.
Yeah. So,
Will cost,
if it's anything, it's like a typical. Yeah, no. I would say like medical directive, power of attorney, because I do them together. you're not gonna come in for a will and me not talk to you about attorney and medical directive. So 3 documents, you're looking at about 600. But for a couple, it's about like 4,000.
What's the, I call that, like if a couple were to get it, they just want to go together.
Yeah.
To say, okay, split up.
Oh, yeah.
What's that?
Cohabitation agreement. Yeah, cohabitation or co-ownership, like, because there's a lot of people that now with the price of housing and things like that, there's a lot of different scenarios of people that are purchasing. So you've got like 2 families that are, this is how we're gonna split the bills and this is.
Is that similar cost as well?
Yeah.
Oh, really?
Yeah. Oh, well, it's about, that's about 1,500, because you're getting into a lot of like you're, yeah, like, well, not even, well, yes, but like, how are we going forward with this? And if they want to get really specific, or to have everything written out. Depends how.
And what happens if one of you want to sell or?
Yeah, yeah. So it did that, but not like infinitely cheaper than litigation.
Even an enduring power of attorney, can that not also be a medical directive, or do they need to be separate?
If the power of attorney has wording. But in 2022. Was the Personal Directives Act that came through. So we definitely try to keep it in 2 separate, because there's a lot more actions and decisions that need to be made for personal directives.
Does that enable a MAID program, or is that still doesn't?
No, MAID is completely separate, and you have to be, the person has to be legally have capacity. MAID. Absolutely.
What is MAID?
Medically assisted. Yeah. Absolutely.
And some people want their medical directive person to be different than their power of
Exactly.
attorney.
Yeah.
I think it's the law. But I know
No.
we have to change ours.
Or you can have the same, well, if you only have 1 child, like, right, like. And you only trust, there's not a whole lot of people trust, like.
Well, and
That
yeah.
many people.
And
Yeah, like-
it's also who is going to be able to make a decision that's not emotionally
Exactly.
driven or emotionally charged, right?
Yeah, like the power of attorney medical directive now allows, like. You could still do that, but it was less common. It allows for, who do you want to be consulted? Do you want many medical professionals do you want to consult on these medical decisions? 1, 2, do you want your family doctor in on the consultation? It's like more of a collaborative approach. And the new medical directive forms that came out, they're actually really good. Assisting people, guiding people.
Maybe that's what, I know we had to split it, maybe.
Yeah, like it's super, and it can be super, like, how many times do you want your hair washed?
Travis has a question. The family members added to deed or title, son or daughter before someone passes, will it automatically go to probate? Assuming then capital gains will be paid by the other person, if not the primary residence. What is the trigger point? It automatically goes to probate.
If a family member is added to deed, title, son, daughter, before someone passes, will automatically go to probate. No, that would typically be joint tenant situation where it wouldn't go to probate, it would pass to son and daughter. A way that people avoid one person inheriting the entire house. They want to add 1 child, they can also add them all on title. Right? So if you've got 4 kids and you want them to all make a decision about the house when they pass and you want to avoid probate, you can put all 4 of your children on title, but the chances are that there's going to be a lot of complications. And I'm assuming that capital gain paid by the added person, if not their career residence. Yeah, so that's exactly why I always recommend speaking to an accountant before and getting instructions.
So you're saying that's when they're on title. What happens if they're not on title? I might have missed this, and they inherit it. If they sell it, don't they have to pay capital gains?
No, there is no tax on inheritance.
So if my mom died, if my wife and I die and not my kid gets it, she can sell it and there's no capital gain whatsoever.
That's correct.
Okay.
More property? Or is it only on primary?
Well, they would, like, the estate
Yeah.
may pay capital gains if the estate owns more than 1 property.
Right, okay.
But if his mom only had owned 1 property and that is then sold, there is no inheritance tax. There's no inheritance tax.
But on an estate, there could be, okay.
Say too many times.
What is the trigger point of automatically goes to probate? Sole ownership is probably the biggest trigger point. Probate. Sole ownership of title. One person when it's going to probate. That's the only way out.
Stacy says, but we do pay half.
The child is on deed and it's not their primary residence. You could, absolutely.
So. If you put a child on deed and they're not living in the province. Do you get into,
Again, saving,
Different
that's
taxes
yeah, and
and-
that's why everything goes through an account. I've got an accountant on speed dial that I say, here, answer this question, because you have to, because like you can't, people have these questions every day.
well, I think of like PEI,
Mhm.
my parents are.
Yep.
One of us was to be put on title
Mhm.
or at a province, so we pay double tax.
Yeah. Exactly, so you have to know you have
Yeah.
to know that before you go on title,
Yeah,
right? Like, you don't want your parents going to their lawyer in PEI, the lawyer saying, sure, I'll do that. It's the consequences, they're ultimately coming back to you.
yeah.
You don't have to sign anything when you're being added on title.
There's mom and dad, and then they just don't say anything.
Exactly, because you don't, because that generation, you didn't.
You're not be on the deed, really. I mean, if you're.
So I think the biggest conversation I have with clients that want to add their children on title, is we actually start with math. We start with math and protection of assets. So I will say, okay, this is what the probate would cost. Yes, it's annoying. Yes, it's a process. Yes, but this is, you're protecting your independence. You're protecting your set. You're protecting all of these things. If you, because you want to sell your house that you've been in for 40 years because you want that money to go to live in a nursing home, and your daughter's like, no, I think I want to keep that because that's more money for me. It's sell. So we have that conversation, and then we have the conversation of what does probate actually cost and what are you giving up? And then once we have that very informed conversation, typically there's much more of an informed decision made.
For a percentage that probate normally is.
It's like, it goes by over 500,000, it's thing. It's 1.6%
The
of the,
raised,
no, assessed.
oh, assessed.
Yeah. Value.
That's not that much.
Right? Oh, it's really just what client's decision. No, inheritance is better from an accounting perspective. Children are added. They have never owned a property, doesn't that then waive? I actually don't know that. If it waives their first time home
Yes.
buyer incentive, I don't know.
I think it
Okay.
does, yeah.
Yes,
I'm pretty
Okay.
sure it
Well, then,
does,
yeah.
yeah.
because then we got owners.
Right, exactly, yeah.
Another question for you, I'm so sorry.
That's
Go back to probate again, so 1 point whatever. If you have to probate. Every asset they have to be probated, not just.
Not if it went joint, not if it, or like life insurance policies, you're gonna want, if you have beneficiaries names, that's going out. When it counts, if it's joint, it's going to that person.
Only if there's a bank account in so-and-so's name that's passed away and houses in.
Only whatever's in total.
But if you had a trust or something, then it will only be the whole, the bank accounts.
Well, again, like, I can't comment on the trust portion because I don't know enough about it and I don't do them, so it's really hard for me to like. Yeah. But there's specialists.
For the people that
They refer
we're
to-
talking
yeah.
about.
Yeah.
They paid the money for it.
Yeah.
Thank you so much for explaining all
You're
this.
welcome. Yeah.
Yeah.
Thank you.
Yeah.
Being paid for that question. Appreciate it, absolutely.
Any other
Me-
questions online?
There's a hard one there, Sherry.
Looks like everybody's.
Aw.
I
Well,
don't,
if you
I don't
think
have
that-
any, I don't have any hard questions left, but I am now concerned about going on title with my mother's property.
Well, just talk to an accountant first, like, that's it. Like, it's definitely a conversation that will be worth its weight in gold. You'll know. You'll know. yeah, what that looks like. Sometimes it makes sense, sometimes it doesn't.
Fair enough.
She's got a food for thought.
Yeah. Like, wheels are churning. I can see them.
I'll re-enter it for one last screenshot.
I'm gonna put it in my office. Tag Dennis in it.
Thanks, Dennis.
That was fantastic.
No problem.
right. Suzanne, thank you so much.
You guys are
This
very
was
welcome.
awesome.
Absolutely.
I think everybody feels a little more prepared in having the conversations and
Sure.
knowing to refer them.
Yeah,
Refer them out.
It's, well,
Right.
and don't just call your lawyer. I mean, seriously,
Yeah.
at that, literally, like, because then we don't have to backtrack.
Mm.
So, yeah. Be my, yes, takeaway. Awesome. All right.
Thank you.
Okay, you're welcome. guys.
Incredible. Thank you so much.
Thank you.
You're welcome.
Thank you, guys. Thank you, everyone, for joining online.